legal action against Indian defaulters to recover around 50,000 crore rupees after New Delhi made the rulings of Emirati courts in civil cases enforceable here in India. While most of the cases involve corporate loans taken by Dubai or Abu Dhabi-based subsidiaries of Indian companies, action is also being planned against individuals, according to a report in the Economic Times. The banks include UAE-based Emirates NBD, Mashreq Bank and Abu Dhabi Commercial Bank. A few other lenders such as Doha Bank, National Bank of Oman and National Bank of Bahrain, which have exposure to Indian entities or citizens through their branches in Dubai or Abu Dhabi, also have either already moved courts in the UAE or are in the process of doing so in the coming weeks, the report added. The Indian government on January 17th issued a notification allowing the decrees of certain UAE courts in civil cases to be enforceable in India. This means a UAE bank, if it has a court order in its favor against a defaulter who has fled to India or no more has operations in the Emirates, can seek to enforce it here like any local lender to recover the money. On this edition of The Big Picture, we will analyze the implications of the move. Joining me on the program today are Ajay Dua, former Secretary, Ministry of Commerce and Industry; Satinder Kapoor, Advocate of the Supreme Court and English Solicitor; and Prabhu Dayal, former Ambassador as well. Thank you, gentlemen, for joining me on this edition of The Big Picture. Satinder Kapoor, let me begin the program with you. Let's first try and understand what the process is of the UAE banks pursuing defaulters here in India.
Well, let me first of all explain to the viewers that there was an agreement between India and the UAE signed, I believe, on the 25th of October 1999, which provided for cooperation between the UAE and India on several fronts. And one of these fronts was execution of decrees of UAE courts in the Indian jurisdiction as executable decrees, as if they were decrees of the Indian court. Now, after a period of almost 2 decades of this agreement, the government of India has, on the 15th or the 17th of January 2020, almost after expiry of 20 years, has decided to notify, by way of a gazette notification, this particular provision, which gives the status of a reciprocating superior court to certain designated courts of the UAE, and I'll explain that to you for a minute. And this has implication that in one of the sections of the Indian CPC, the Civil Procedure Code, in fact section 44A of the Civil Procedure Code, which provides for certain foreign money decrees. Now, very important to understand, these are not any decrees, but these are money decrees which are enforceable under the CPC as if it is a decree of the civil court of any court of relevant jurisdiction in India, executed against assets in India of certain parties against whom the judgment is or the decree has been awarded.
Right.
Now, by way of implication of this notification of the government, we have now, India has recognized certain courts of the UAE as reciprocating courts. Superior courts is the term used in this particular section of 44A of the CPC, granting jurisdiction to the courts, certain courts, and there are 2 federal courts and 5 what you call the state or the non-federal or the state courts of the different Emirates. As you know, UAE consists of 7 different Emirates.
Correct.
So they have 2 federal courts, well, almost equivalent to the Indian Supreme Court. They have been granted the status of a reciprocating court of a superior court in a reciprocating territory under 44A of the CPC. And there are 5 different courts, including Dubai, Fujairah, Amman, etc., of different Emirates of the UAE. Any of the decrees, money decrees, emanating from any of these 7 different types of courts would now, as of 17th of January 2020, be executable in India as if it were a decree of the Indian court. Now, I must hasten to add that the process is not as simple as it seems to be on the face of it.
Okay. Mr. Kapoor, we'll get to, what the process is and how simple or how difficult it is in just a bit. But let me get the other panelists into the picture as well, and then we'll take the discussion forward. Ambassador, this is not something new. Economic offences of this type have been going on for a long time now. I very clearly remember, because my parents happened to be there in 2008 during the recession. We saw several, Indians drive their cars to the airport or leave their cars in basements and then come back to India, and nothing was really done back then. So why is it that the UAE banks have decided to do this now?
Well, I think the UAE banks and other financial institutions have been trying for a long time to work out such an arrangement. Because, as you said, there were umpteen cases of people defaulting on their bank loans and fleeing to India. Not just India, there are people who have fled to other countries.
Yes, to the West as well,
host nations. Now, there was no way by which the UAE banks were able to enforce the judgments of the courts there, because there was something lacking in our civil procedure code. I think our court said that there is no specific notification to the effect that the judgment of the UAE court could be enforced by an Indian court. So that is why the government of India has now, as was mentioned by Mr. Kapoor, declared that the UAE would be considered a reciprocating territory, and that the judgments of the UAE courts would be enforceable by Indian courts. I must tell you that not only was it in the economic slump down of 2008, which you referred to, that people flee, but from much, much earlier. I was posted in Dubai till 1998, and there was a lot of pressure from the UAE side to have such an agreement, and that is why the following year, in 1999, an agreement of this nature was signed. There was also an agreement on cooperation in criminal matters, on legal assistance in criminal matters, because there we had a lot of concerns. And I must point out to you that there were a lot of people who were fugitives from the Indian judicial system, including from the infamous D company, who had taken refuge in UAE, and we were pressing the UAE authorities to hand over those people to us. And with one excuse or the other, they wouldn't hand them over. And it was a very, very difficult task to try and persuade them. So that's why that agreement on cooperation in legal matters, including criminal matters, was signed. And at the same time, because there was a lot of pressure from the UAE side, this other agreement on cooperation in civil matters, including commercial matters, was signed, as was mentioned by Mr. Kapoor.
So times have changed now, 20 years later, and that's what, and as a result, we are seeing all of this, take some kind of protection. Okay, all right, Mr. Dua, how big an issue is it to deal with international economic offenders, and what kind of an impact do these offenders have on the economic system or on the economy itself?
At one point of time, when India hadn't really opened up to the rest of the world, I'm talking to the period prior to 1991, probably the impact of such actions outside India by Indian subsidiaries or main companies or Indian companies by themselves or even Indian retail borrowers was probably not much, because we had huge restrictions on capital flows. We hadn't opened up to the world. But post that, I think gradually, now that we are getting integrated with the global trade markets, commodity markets, and now increasingly in the currency and capital market as well, though it isn't complete as yet in the capital market integration, but we have fairly high flows of capital between India and the rest of the world. It has become an important matter, and what happens vis-a-vis one country can impact the other hugely. For instance, the case which we are talking about of UAE, it is reported that about 50,000 crore rupees, that's a current currency value 7 billion US dollars, is the amount of money which is involved with which is of these 9 banks in the UAE, borrowed by Indian corporates, their subsidiaries, and even Indian retail borrowers. Retail borrowers, they treat it as somebody who's borrowed up to 20 million rupees, 2 crore rupees, so even that can be substantial. So to that extent, $7 billion of money borrowed in UAE, it might be in India, it might be somewhere else, but cumulatively, if this is done elsewhere also, it can have a huge impact on the country's currency, our currency. It can have a huge impact on our balance of, the balance of trade, in which the capital flows also, apart from the current account deficit, the overall deficit, and those kind of things makes such actions, cooperations or not cooperating, also a matter of concern for the economy.
Right, right. Okay. Satinder Kapoor, let me come back to you now. I'm sorry I cut you short while you were talking about some of the challenges really in actually seeing this through. So what are some of the biggest challenges, and do you see the process being completed fully? Because there's going to be a lot of legal paperwork that needs to be completed, probably some international laws to be dealt with, and so on and so forth.
Well, thank you. I think the biggest challenge which this entire process is now going to be faced with is another provision in the same CPC, which provides for this section, which talks about certain defenses which are available to people and companies against whom these decrees are being executed or are potentially going to be executed. And these defenses, there are several of them, and they are there as a matter of technical detail. They mentioned in section 13 of the same CPC. For instance, a decree given by a UAE court in this instance would need to be in terms of the public policy of India. It should not be in contradiction to any provision of law in India. Now, it should be given by a court of proper jurisdiction in the UAE. It should be a decree on merits, and it should be a money decree, blah, blah. There are many such defenses. So what happens is, when you come to execute a foreign decree of a superior court, for example, the courts of Scotland in Edinburgh and the courts of England have been on this list for many years. But I personally have to come across, and in fact I'm personally trying to pursue one such decree from the English court, the English High Court in London, in an Indian court, specifically in the Saket court in New Delhi. For the last 6 years I've been at it. But because of the defenses which are available to the party against whom we are executing, we have not yet been able to successfully execute an English decree in the Indian court. So I am afraid, and I speak with a degree of skepticism, that with this newly conferred status on the UAE court, I think a lot remains to be seen how the Indian courts treat a UAE decree, because there are substantial procedural differences between how a UAE court works and how an Indian court works. And I've had experience of the last 15 years in UAE courts personally, and I can tell you from personal knowledge, I believe it's going to be an extremely tedious job for the banks of the UAE to be able to get a decree and enforce it successfully. Maybe it might take a while for the law in this regard to settle down because of the peculiar nature of the UAE courts. The procedural differences are tremendous. I mean, I could write a book about it.
Okay, all right.
So I would say that all banks and people who are chasing such decrees should keep in mind the defenses which are available to the parties in India under the Indian CPC, and tailor their judicial documentation before the UAE courts to be in line, keeping in mind the potential challenges which the Indian parties are going to raise against a decree of the UAE court. So I believe I think time will tell how this area develops as far as UAE is concerned.
Okay, all right. So, Master, you know, the first thing that came to mind, one of the first few things that came to my mind when I saw this, when I read this report, was the extradition of Christian Michel that took place, you know, a few months ago. So, there has been a lot of cooperation between India and UAE, you know, on the criminal side as well, and now we're seeing it as far as economic offenders are concerned too. So, are we going to see more cooperation between the UAE and India in the days and months and years to come to deal with combined issues?
Well,
of this kind, of this nature?
Let me say that my reading is that cooperation between India and the UAE in the legal sphere has been increasing over the years. As I mentioned, it was very, very minimal in the time that I was posted in Dubai from 94 to 98. And we had difficulties persuading the UAE authorities to extradite some criminals to India. Since then, things have changed. These two agreements which I referred to earlier on the criminal matters and also the one on civil matters were both signed between the two governments. And there has been progress, though of course there have been legal impediments also. Apart from Christian Michel, if I can recall correctly, some other members of the Dawood gang had been extradited by the UAE to India. Of course, many of the others had fled from the UAE and they are hiding in Pakistan, which is totally unwilling to acknowledge their presence. But there has been cooperation extended by the two sides. Of course, there are legal impediments, and Mr. Kapoor was absolutely right in pointing out that the Indian courts will examine very carefully whether a particular order or decree of UAE court is applicable in the Indian context. The legal eagles will have to work over time to find the right way out. But from a point of view of a diplomat, I must say that it augurs well for the cooperation between the two countries that the Indian government has gone ahead with making this little amendment to the Civil Procedure Code and including the UAE as a reciprocating territory.
Sure, sure. You know, Mr. Dua, the report very clearly states how most of the cases involve corporate loans taken by, of course, Indian firms whose arms are in Abu Dhabi and Dubai and so on and so forth. So, who then will be held accountable when these banks go after these defaulters?
Very much the companies, management of those subsidiary companies. In the first instance, the management of the subsidiary companies. If those banks, or sorry, those borrowing entities have closed their operations and fled to India, then under this agreement or under this, after this notification has been issued, treating each other as a reciprocating territory under the under the CPC, the promoters or the management, the part of the management which is in India, that's going to be held responsible to execute the decrees.
So, is it going to be the entire management? Is it going to be select few?
The fact of the matter is, it is defined, and under the company law also, you first go after the promoter directors. Then the next level is the directors of the company. Then would be the employees who are part, what they call KMPs, key management personnel. You know, so those kind of things are known. But the problem is going to be the subsidiary company is no longer there in the, it's closed, shut its shop. The people who are involved with running it are not in India also to be found, or they cannot be found in India. Then where do you look for them? Then that becomes an issue for the administration and the courts in Dubai to locate them and go after. So basically it is under this, with this notification in position, it is first the subsidiaries which are there. You didn't need a notification like this to go after them because they are still very much in territory of the UAE. Now, if those guys have fled and they are in India, the main companies are here, subsidiaries obligations also under certain circumstances fall on the parent company. Then it is these people who will have to make good the court, whatever the court has ordered after the due process has been established and the Indian courts have upheld those charges. It's very simple in the case of retail loans. If the guys are here,
yes,
then the Indian courts, these guys can appeal that against the order, etc. But once the Indian courts also uphold it, if challenged, then they can be executed against these people. Execution can be by way of attaching their assets. It can be by way of filing proceedings against them under the recently enacted bankruptcy, the bankruptcy code,
IBC.
the IBC insolvency provisions, and in certain circumstances against the retail persons, it could even be criminal if it has been established that there are bona fides which are questionable.
Right. Okay. Let's take the discussion forward now. Mr. Kapoor, you touched upon this aspect in your previous comments, so let's go back and try and address them at length. So, what are the rights of the defaulters in this kind of a scenario, and what are their legal options?
Well, I may just add to the last discussion on what would happen and who would get sued and whose properties would get attached. Now, I would just like to add to my learned friend's statement. In the case of borrowers, corporate borrowers in the UAE, I'm sure there are many cases in which the promoters of the companies in the UAE, who are largely Indian, I believe that we're talking about, would have given personal guarantees to the UAE banks in support of the debt which has been taken over by the companies, of which they are the promoters. So I believe that action would also be taken by the UAE banks by invoking their rights against the personal guarantees of these Indian promoters, who unfortunately maybe have left the UAE and have come back to India, and they hold up in India. And I'll come to the other situation in a minute. This particular notification would also empower the banks to seek redress against the personal assets of the promoters of the companies, the promoters and the promoter directors of the companies, especially the guarantors, who have taken the monies, not paid them back, and now they have shifted back into India. And they've got their properties, they've got their building, they've got their residences or whatever, the businesses which belong to them, they can also be attached under this notification. But before I come back to the next point, I would just like to add one thought. That since this is a reciprocating kind of a provision, the logical question is, are decrees from designated Indian courts, are they executable against such parties who have gone and holed up in the UAE, who have left India and gone back? They've taken money from the Indian banking system or maybe under a contract, and they're in breach of it and they've run away to Dubai. So the word reciprocating suggests that we should equally be in a position, the Indian decrees should be equally in a position to be executable in the UAE. But I'm afraid I have not seen such a notification from the UAE side. Whether it's automatic, when India declares UAE as a reciprocating country, does it automatically mean that India is also a reciprocating territory for the UAE? I am yet to examine this issue, because I've not yet seen this particular notification or a diktat from the rulers of the UAE, which I think is going to be important for me to see this.
Right.
As regards your question of defenses which are available, because there should be defenses which are available to people against whom decrees are going to be executed under this newly developed notification. And like I mentioned to you, there are several defenses, and I think one of the main defense is going to be whether a due process of law, and I'm sure my friends would agree with me, whether a due process of law as contemplated under the Indian statutory provisions, whether a similar due process of law has been followed by the UAE court or not.
Right.
Because if they are reciprocating, then the standards of getting a degree and the procedure of getting a degree, which I mentioned earlier, have to be on a similar footing.
Sure.
And I believe the due process of law as far as the UAE court is quite different. And my main hesitation as a lawyer who's been dealing with international aspects of comparative international situations is whether an Indian court believes that the due process of law standard, procedurally and otherwise, equitably, followed by a UAE court, a designated UAE court, passes the test of due process of law as contemplated under the Indian statutory provisions, Indian guidelines, and Indian laws which have been upheld by the Supreme Court of Honorable Supreme Court of India. So this is going to be a challenge.
Okay, the challenges and the difficulties have been pointed out by you. I'm sorry, Mr. Kapoor, I'm going to cut you short because I've got paucity of time. So let me get closing comments from the other two panelists who are here with me in the studio as well. Ambassador, what's the best way forward?
Well, the best way forward is for the two governments, UAE and India, to continue to work closely together to bridge any gaps which may be existing. Mr. Kapoor very rightly pointed out that there would be many different obstacles which could be confronted, and that judicial decrees are liable to be interpreted differently. So there is a necessity to bridge the gaps in the understandings of the different legal systems, and the two governments have to work together. But the bottom line is that the doors are shutting for economic offenders the world over.
Absolutely.
Economic offenders from India should also watch out that we are engaged in discussions with other countries to bring them back. And it should become impossible for people to loot money from banks from here and flee to other countries.
And vice versa.
And vice versa.
All right. And Mr. Dua, close the show for us with your concluding remarks.
If this reciprocating agreement, to which it was just mentioned that this the UAE authorities or rulers have yet to issue it, I would expect that notification to be also issued immediately, because that's the reciprocation act which is required. Number one. Number two, I think the Indian government would need to explain this very clearly to its counterparts in the UAE, that their orders, the court orders to be enforceable in India, should have met a particular standards set by the Indian courts. So before issuing these, and these getting negated by Indian courts, will actually be a kind of a disruptor and a disappointing thing for the UAE banks. But rather than pass these notification orders in a hurry, just at the behest of the behest of the banks which have lent the money, the UAE courts will do well to follow the Indian system, the minimum standard